Hi, Jeff Segal here, and today we're going to talk about the National Practitioner Data Bank and how to stay out of it. A few words about me. I'm both a physician and an attorney, board-certified neurosurgeon, and I defend doctors, mostly focused on professional liability, also online defamation, and a smattering of other medical legal risks, including medical board complaints and reports to the National Practitioner Data Bank, which is the topic of today's discussion. I'm also a partner at a law firm called Bird Adato, which has a national footprint. All right, so let's dive in the National Practitioner Data Bank. So I'm a doctor, also a lawyer, but here is my data bank report. I downloaded it 2022. It hasn't changed since. At least I don't think it's changed. But in any event, it's clean. It's short. That's what you want. You want a plain vanilla, short National Practitioner Data Bank report that has nothing on it. And there are a number of ways that you become a line item in the data bank. And these are the main ways. They're not the only ways, but these are the main ways. If you are sued for professional liability and your insurance carrier pays a settlement or a judgment on your behalf, you will be reported to the data bank. Not always. There are some exceptions. We'll probably talk about that in a bit, but that is the dominant way most doctors end up in the data bank. If the hospital where you have privileges restricts your privileges for more than 30 days, you will get listed in the data bank. And if there's any discipline on your medical license, you will be reported to the data bank. There are other ways to get reported, but these are the dominant ways you end up as a line item in the data bank. All right, so let's start with a medical malpractice lawsuit. And the way it starts is, at least in terms of reportability, a demand must be made in writing for money. Demand must be made in writing for money, alleging you did something wrong, professional negligence. Now, they need to ask for money. It can't just be, you did something wrong and I want you to apologize. It needs to be something of value. It could be that, hey, I need you to send me flowers. Flowers would be consideration because flowers have value, but nobody's really asking for flowers, to make a matter go away. But if they're asking for money in writing, that would set the threshold. The payment must be made by a carrier on your behalf. The carrier could be a self-insured hospital that you work for. That could be a carrier. But if you make the payment out of pocket, not reportable. If the carrier makes payment, it is reportable. Okay. So if you make the payment out of pocket and there's no carrier involved, is it reportable? No. The answer is no. And I have a number of clients who work with high-end patients that have paid a lot of money and they just don't like their outcome. They want their money back. Is that reportable? No. If the doctor made the payment out of pocket, it is not typically reportable to the National Practitioner Data Bank. What if the demand was never made in writing? What if it was just a diatribe on the phone? Is that reportable? Nope, not reportable. According to the data bank, it's got to be in writing. And what if the payment is merely for reimbursement of legal expenses and no money goes to the plaintiff? So let me give an example. Let us say that you're in the middle of litigation and you have a carrier that is paid for an attorney, and ultimately this is dragged on for about 4 years. And there's not much of a case. The other side is not going to go away for whatever reason. They said, look, we just want to get back to break even. We just want to make sure the money we expended on expert witnesses and transcription, et cetera, is reimbursed. And we're willing to go away at that point. If you reimburse the attorney for the legal expenses, is that reportable to the data bank? And the answer is typically not, because no money has gone to the plaintiff, which in this case is your patient. So if no money goes to the plaintiff, and that can be reconstructed through a settlement release agreement, meaning that it's clear that no money went to the plaintiff, not reportable to the data bank. There's a myth that there's some threshold dollar amount that triggers reporting. Some people think it's $30,000. Some people think it's more than $100,000. It turns out if the carrier has made a payment in response to a demand for money in writing, it doesn't matter if it was $1, 1 million, or $10 million. The carrier must report. There is no minimum dollar threshold for reporting. Now, and I think this is where the myth got started, is that in some states, they have a parallel reporting requirement. So in California, for example, if you or your carrier pay out more than $30,000, that's more than 30, so that's $30,000 and 1 penny, you have to report to the state, or they report to the state. In Virginia, it's $10,000. So most states don't have a minimum threshold requirement. Some states do. If your state does, you have to be aware of it, because even if you don't report to the data bank, you may have to report to the state, and vice versa. There may be an obligation to report to the state, not the data bank, and not to the data bank, but to the state, et cetera. So something to chat with your attorney as you try and figure out what to do, whether settle, whether you're going to pay out of pocket, if so, how much, and so on and so forth. But there is no minimum dollar threshold for reporting a professional liability payment to the data bank. All right, I want you to take your time and just read this in detail. I'm just kidding. This is the California rule. It's a state rule which says that a settlement over $30,000 is reportable. So what happens if it's not a settlement? Let's say the patient demands their money back and they paid $45,000. If you give them back their money, do you have to report to the state? Well, it depends whether it's a settlement or not. A settlement is usually associated with an agreement that the matter is terminated. You want something in writing, which basically says, you will not sue me going forward. You won't post nasty stuff about me on the internet. That would be a settlement. But if you're just giving them back their money, even if it is over 30,000, in my example, 45,000, arguably it's not a settlement. It's just a refund with no strings attached, meaning they can still sue you if they want. I'm not a fan of writing a check for $45,000 without a settlement agreement. But, to the extent you're trying to figure out whether it's more important to report to the board or to have closure with your patient so they can't engage in any legal or online mischief down the road, this is a fact that you'd want to take into account. In California, if you or your carrier write a check for over $30,000, and it's considered a settlement, meaning that everybody signs on the dotted line and this is the end of the matter, that is a settlement. It does need to be reported to the California Board of Medicine. Virginia has a parallel type of requirement. The threshold is lower. It's only $10,000 in terms of reporting a judgment or settlement. All right, let's migrate over to hospital privileges. That's not one of the larger buckets for reporting to the data bank, but it's not an insignificant one. So if there's an adverse action on your privileges, and an adverse action could mean a reduction, restriction, suspension, or revocation of your privileges, and it lasts for more than 30 days, that is reportable. It's also tied to a denial of privileges if based on professional review. And here are some things that are quite interesting. If you surrender your privileges or choose not to renew while under investigation, and that's important, while under investigation, there's no 30-day window. It's immediate. And this is a distinction that is often lost on physicians because they've heard the number 30 days. And they seem to believe somehow that they can get out of Dodge in under 30 days, even though they're under investigation, without cleaning up all these loose ends. And if they just leave before the 30-day threshold hits, not reportable to the data bank. But in point of fact, if you surrender your privileges or don't renew your privileges while under investigation, the hospital can and does report immediately. Summary suspensions, assuming that there's a professional review in effect for 30 days, reportable to the data bank, even if they've not taken a final action on your privileges. Even if they give you back your privileges, full privileges, after they've done their formal investigation on day 45, for example, they'll report that you were suspended, and then they'll report that you had your full privileges restored, but you still have that ugly scar in the data bank. So what is an adverse action? An adverse action is focused on a doctor's professional competence or conduct that could adversely affect, or that adversely affects, or could adversely affect health and welfare of a patient. This is a very broad definition. Now, what if a doctor throws instruments against the wall? No one's been injured. The doctor may be labeled as a disruptive physician. Could that lead to an adverse action? Arguably, yes. They're not talking about your professional competence, but it is conduct that could adversely affect health and welfare of a patient. In particular, it could affect your team. And if your team doesn't deliver good work, then some patient down the road could be injured. You can see the deck is stacked against the doctor here. What about administrative dismissals, meaning you lose your privileges for an administrative or clerical reason, not as a result of an investigation? So these are typically not reportable because there's not an associated professional review action. So let me color this with an example. Let's assume the bylaws mandate that doctors be board certified in their specialty, and that for whatever reason, your maintenance of certification expires. You choose not to renew it, and then the hospital automatically revokes the clinical privileges because it's automatic. It's in the bylaws, but it's an administrative action. It's not as a result of an investigation. Here, the revocation of clinical privileges was not by a formal professional review action, it's administrative. So there should be no data bank report. The investigation itself is not reportable. It's an adverse action, but as I alluded to earlier, you can't just simply walk away, take a leave of absence, surrender your privileges to avoid being investigated or reported. The hospital must report if any of these occur during or to avoid investigation. For example, you, the doctor, chooses not to renew your clinical privileges, or you surrender your clinical privileges. Or and this is something to be very wary of. I've seen this little tricky thing happen many, many times. The chief of staff will talk to the doctor and say, look, we're going to investigate you right now. What we want you to do is to avoid exercising your clinical privileges. Don't go to the operating room. So we'll do our best to do a quick investigation, and we'll be able to have an answer within 30 days. And hopefully there will be no formal action on your privileges. Okay, so the doctor says, okay, so you're asking me to agree to not go to the operating room, to give you some breathing room to review any action against me. Yeah, I'll do that because I don't want to be reported. Now, if you, the doctor, agree to refrain from exercising your privileges, that's a voluntary restriction of your privileges, and it is immediately reportable to the data bank. There's no 30-day window. So if the hospital takes an action against you and it lasts for more than 30 days, that's reportable. If you take your own preemptive action while under investigation, either restricting your privileges or going by, it doesn't matter how you characterize it. It could be a leave of absence. You can call it educational leave. it's immediately reportable. And to make matters even worse, this is the case whether or not you were even aware there was an investigation. So before you leave an institution, if there's any belief whatsoever there may be an investigation, you can say, look, I resign my privileges contingent on there not being an investigation. You smoke them out. You're basically asking if there's an investigation. If the answer is, well, we accept your resignation, they're telling you there was no concurrent investigation. So the coast is clear, you can leave. But if you don't ask the question, they are under no obligation to inform you whether or not there was an investigation. This is stated clearly in the data bank. The data bank says you may or may not know as a doctor whether you were being investigated, but if there was a background investigation and you resign your privileges or don't renew your privileges or restrict your privileges, immediately reportable. All right. A routine review, which would look at all doctors kind of in the same way, is not an investigation. An investigation, to be a big I investigation, must be focused on a specific doctor and started because there are concerns about competency or professional conduct. And that competency or professional conduct must be something that either did or could affect patient care. Now, sometimes if a routine broad-based review uncovers an area of concern and later becomes an individualized focus on competency or conduct, it can transform into a big I investigation. I'm calling this big I investigation, meaning something that ultimately could lead to a professional review and an adverse action. All right, what about proctoring? Is proctoring a restriction, yes or no? So let's just go through some examples here. If you must, let's say the hospital delivers an action and says you have to have a proctor to perform a surgical case, and it takes more than 30 days for you to complete this proctoring restriction, that is reportable. Now this is an individualized proctoring. If it's not applicable to all doctors, just as a way to get in the door, then this is individualized to you, can actually be perceived as an adverse action. But let's define this different. Let's define proctoring as not something that you need to take a patient into the operating room, but if you just need to go over cases with a seasoned, wise individual after the fact, let's say once a week, that's not a restriction. Why? Because you could take your patient to the operating room. You just need to go over this case after the fact. But if you have to have a proctor to get into the operating room to start your case, and it takes more than 30 days, well, yes, that would be a restriction and potentially reportable. I think I alluded to this earlier. If you're a new doctor at many facilities, they mandate that you undergo proctoring by, let's say, 5 cases before you're granted independent privileges. Is that reportable even if it takes more than 30 days? No, it's not reportable because it is routine for all clinicians. It's not uniquely applicable to you. So here you didn't have privileges to begin with. So there was no particular issue related to conduct or competence. You just need to go through the process that everybody's going through. All right, some of the rules. Hospital, if it has an adverse action, it needs to report within 30 days. But let's say they take 45 days. Does that mean that you can stuff the databank report out or get it voided? And the answer is no. There's actually no statute of limitations related to a hospital's duty to report. If they forget about it and they get to it a couple of years later, they still have an obligation to report. So would you win if you dispute that? No, you're only going to win if the underlying facts which led to the report were not reportable. So if they take their time, too bad for you. Hopefully, if they take their time, they truly do forget about it and it never gets reported in the first place. All right, so Sometimes the doctor will say, if you look at the bylaws, the hospital didn't follow its own bylaws in the investigation. But ultimately, the data bank doesn't really care how the hospital interprets an investigation. The data bank ultimately is the lexicographer as to whether an investigation occurred, because investigations are the necessary precursor to a professional review action, and a professional review action is what is needed to get to an adverse action, which would be reportable to the data bank. So ultimately, investigations continue until the investigative body takes its final decision-making action, which means investigations can actually linger longer than you think they're going to linger. Before you leave an institution, if you don't know whether investigation is closed and whether the coast is clear, you need to ask. And one way I like doing it is by just making any resignation contingent on there not being an investigation still ongoing. So for example, I resigned my privileges effective today, contingent or conditioned on there not being an open investigation. And if they accept your resignation, it's likely. In fact, you can rely on the fact that there was no open investigation on the day of your resignation. All right. So here's an example of a doctor being under review and given a choice. Submit to some type of monitoring of the type of care you're delivering, as well as CME, or your privileges will be suspended. So here you're being given a choice. Presumably, the investigation is still ongoing because you haven't made your selection yet. So if you decide to leave, if you decide to non-renew your privileges, and it's under investigation, as I've stated over and over and over again, this is reportable. And it doesn't matter whether you were aware of an open, ongoing investigation or not. If you don't, in addition, if you withdraw a renewal application while under investigation, it is reportable. Again, it doesn't matter whether you are aware of the ongoing investigation or not. Is there any good news? Yes, there actually is one little bit of good news. There's an exception to this. If it's a new application and not a renewal application, and you withdraw the application, it's not reportable, even if it was an investigation. So there are certain circumstances where even with an investigation, you can avoid a report to the data bank. Here is the example. If it's a new application for clinical privileges and you withdraw your application for those privileges with a new application, not a renewal application, it's not reportable, even if there was an open investigation. All right. Say the medical executive committee recommended that a doctor not be reappointed, and the doctor's current 2-year appointment ends before he can even defend himself at a fair hearing. Is that reportable? Sadly, it probably is reportable, even though you never would have gotten your day in court. A fair hearing not being really court, but it's your ability to defend yourself. If the medical executive committee was looking into a competence issue, the data bank argues it doesn't want the clock to run out, so they want reporting to take place. From their perspective, they just want to know, was there an investigation? And if ultimately you were not renewed during that window of time when there was an investigation, you get labeled in the data bank non-renewal while under investigation. And this goes back to 1986 under the Healthcare Quality Improvement Act. So it's a law that's been around for decades, and the data bank doesn't have the flexibility to amend that on its own. It would have to be done through Congress. What if you're fired? Let's say that you're a W-2 employee for a physician group and you have parallel privileges with the hospital. Your employment contract termination, typically in and of itself, not reportable to the data bank because it's not a clinical privileging action. It's an HR action, human resources action, human resources decision. There certainly are situations where you have an employment agreement where a term states you must maintain active privileges at a sister hospital. And if you lose your privileges, you lose your job. And the flip side is also true. If you're fired or you terminate your employment with a physician group, you automatically lose your hospital privileges. In one of those circumstances, where it's a primary employment action and you automatically and administratively lose your hospital privileges, that's generally not reportable. Why? It's an administrative action. It's not the result of a professional review action related to an investigation. So how these things get sequenced can ultimately determine whether you will be reported to the data bank. Many doctors today are W-2 employees of physician groups that have very close relationships with hospitals. And if there's a potential way to sequence this, so it's primarily perceived as a employment decision or an HR decision as opposed to a clinical privileging decision, you'll end up with a better outcome with no report to the National Practitioner Data Bank. All right. I think we talked about this earlier. I'll repeat it. If you agree not to exercise clinical privileges while under investigation, that is immediately reportable. It's also reportable if you state that you will not exercise privileges instead of performing an investigation, instead of the hospital performing an investigation, also reportable. And it's reportable immediately, and there's a line item which describes it as resignation while under investigation. And in my mind, these are really terrible line items because it is assumed by whoever reads this down the road that you resign because there's something really bad out there and you didn't want those facts to see the light of day. So you'd rather just leave and just have people come to the conclusion that there was something, but they don't know what it is. But human nature being what it is, people fill in the blanks with the worst possible facts. So I'm not a fan of resigning while under investigation. I think if you can negotiate a mechanism to have this treated administratively as an action, particularly if it's more of an employment-related action as opposed to a hospital privileging action, great. That's a better outcome. But the longer these things linger, the harder it is for you to get that type of outcome. So at the first sign of trouble, if it looks like you may be better off at a different institution, before this is turned into an investigation, which could turn into an adverse action, see whether there's an opportunity for your attorney to negotiate with hospital counsel and or the physician group counsel to see if there's a path out which doesn't label you as someone who needs to be in the data bank. What about FPPEs or performance improvement plans? So what is an FPPE? It's a focused professional practice evaluation. They're not uncommon in with physician groups. They want to see you do better and they commit this to writing. Is that reportable? Generally not, because these are typically voluntary agreements. They're not adverse actions, they're voluntary agreements. But the subtext is that if you choose not to participate, if you choose not to do the FPPE or complete the FPPE, the subtext is that this could lead to an adverse action and that would be reportable. So FPPEs and performance improvement plans are there to send you a warning, to explain what their expectations are, and that if you don't follow the program, danger is coming down the road, potentially leading to a reportable adverse action. All right, state medical board action. That's the third bucket that's here. And it's typically related to disciplinary action on your license. So disciplinary action is an adverse action taken by a licensing authority as a result of a formal proceeding. And the list of discipline is not infinite. I'll just go through it. Revocation or suspension of a license, any type of consent agreement, as to a limitation of your practice, your agreement, or any limitation of participating in a government healthcare program, reprimand, censure, or probation. So a reprimand is discipline. A reprimand is discipline, even though you have your full privileges. You can go back to work the next day. There's not been a restriction on your license, but a reprimand or a censure is considered discipline and reportable to the data bank. So formal proceeding would be conducted by the licensing entity, and formal means that there are formal rules and policies and procedures. Often it's a hearing. It could be a hearing before the Board of Medicine or before an administrative law judge, and it just varies by state. Some states use administrative law judges for the hearing, like California. Other states, like North Carolina, have a hearing process in front of the full medical board. Every state is different. So board action can also include voluntary surrender of your license, where you take the action of giving up your license, particularly during an investigation, or even non-renewal of your license application while under investigation. So these are things that are reportable, even though you have foregone your right to a hearing. If you voluntarily surrender your license, or if you make a decision not to renew your license while under investigation, you've made an immediate decision to allow the board to report you to the data bank. All right, so this is, we'll make this available in notes, but there are some actions that are not labeled as disciplinary. They could even be public. They could be public actions taken by the board that are not disciplinary. So let me just give the broad example. I did tell you that a reprimand is considered discipline. Reprimand is considered discipline. In some states, they allow for a public or private letter of concern. A public or private letter of concern. And if the state regulations label a public or private letter of concern as non-disciplinary, not reportable to the data bank. And so in some states, not all states, there's the opportunity to ask for a private letter of concern as opposed to a reprimand. And in doing so, you would avoid reporting to the data bank if the state accepts your position and they decide that a letter of concern makes more sense as opposed to a reprimand, which is considered discipline. Reprimand is public, reprimand is reportable to the data bank. So part of this will depend upon the state that you live in, whether a private letter of concern or even public letter of concern is even available. And if so, how do these state regulations treat that? Is it considered disciplinary or not? If your state regulations treat it as non-disciplinary, not reportable to the data bank. All right, I'm often asked, can a data bank report be voided? And the answer is yes. So in this particular situation, this is a real world example of a report of a voluntary surrender of clinical privileges while under investigation. If you look at the bottom, you can see that this is a clinical privilege adverse action. The date that this report was downloaded was on February 15th, 2023. That's not when the adverse action took place. It's just when I actually asked for the download. But we were able to petition the board, or actually we were able to petition the facility to void the report. The reporting entity, we asked them to reverse what it did. And here, 6 months later, they did void the report. So there is no report. This is now a clean report. And to the extent that others entities had queried the data bank and received information that the doctor had an adverse action, they will preemptively or proactively receive an update which says that the report was voided. So any decision you made based on a prior adverse action should be rethought. All right, so let's wrap up. Nobody wants to be in the data bank. There are three main ways to get into the data bank. It's with a professional liability payment by your carrier, an adverse action on your clinical privileges, or discipline on your license. The amount of threshold payment for med mal, which allows it to be reportable by a carrier, is $1. It's not even $1, it could be 1 cent. But any amount of money paid to the other side in exchange in relationship to a written demand for cash alleging some type of negligence, that's reportable. If you decide to pay out of pocket, whether it's $100 or $1 million, is that reportable? No, it is not reportable to the data bank. There may be some reports that need to be made to the state licensing board, but in terms of the data bank, if you make the payment, it is typically not reportable. Hospital privileges, if there's an adverse action that lasts more than 30 days, adverse action meaning that the hospital imposed its action on you, immediately reportable. If you resign while under investigation, it is immediately reportable whether or not you knew of an investigation. Can databank reports be voided? Yes. The easiest way, and I wouldn't say that's particularly easy, is to have the reporting entity void the report. There are things that you can do with the data bank. You can certainly dispute a report, arguing with evidence that the report never should have been made because it didn't meet threshold criteria for reporting. But the easiest way to get a report voided, to the extent you would ever call it easy, would be for the reporting entity to actually do the voiding itself. Can you tell your side of the story? You can. You can submit what is called a subject response. You can't do this with reams and reams of paper. It's limited to 4,000 characters, spaces included, but you can get your side of the story out there as long as you can do it in 4,000 characters or less. And finally, if you are reported to the data bank, it's often not a career ender because many doctors are listed in the data bank. Some of them are pretty severe, and if it is severe, it could be fatal to your career. But if it's just, hey, the doctor made a $50,000 payment or his carrier made a $50,000 payment to an allegation of professional liability, and the main reason for the payment being made was to avoid the headache of and uncertainty of litigation, that's not going to be a career ender. What could be a career ender is that you had sex with a patient and you're a psychiatrist and you ultimately got a 3-year suspension of your license. That is a hard one to overcome. So a lot of this depends upon the details. I would tell most doctors you do not want to be in the database if you are in the data bank. If you are in the data bank, it's typically, but not always, a career, and it's not a career ender for most doctors. But by and large, there are tools that are available to prevent you from getting into the data bank. You really need to understand where you are in the process and get help sooner rather than later. Get help sooner rather than later, because once you're in the data bank, it's harder to get yourself out of it than to avoid getting into the data bank in the first place. All right, and with that, we wrap up. With our organization, Medical Justice, we have spent 2 decades just managing all the types of medical legal threats that practices face. And one of the threats we deal with is National Practitioner Data Bank reports, how to avoid getting reported to the data bank, and if you're in the data bank, how to potentially get out of it if it's indeed possible. All right, thank you so much for your attention. More to come down the road.